I'm the attorney that represented Ms. Roberts as well as Dr. DeKalb and Mr. Brown in the Roberts v. Deal matter, in which they were removed under Title 45, which is not specifically the education code. It's Title 45, and it dealt with ethics in government. The court ruled that that law did not apply to bodies created by general statute. Elected school board members are constitutional officers just like you. And the state Supreme Court ruled that that law, the way it was written, the way your body had written that law, was not in such a way to apply to constitutional officers. In fact, if you look at the state constitution, there's nothing under the enabling provisions creating local school board members that says that they can be removed as provided by law. That is what I anticipate is going to be the big contention before the state Supreme Court. One of the issues that comes before the state Supreme Court. Now, it's obvious to me that citizens of Georgia are concerned about two things that are coming together here: education and the right to vote. And I think I think citizens need to spend more time worried about education, because we all know that boards of education collect more tax revenue and spend more money than county commissions. So citizens need to be more involved in that. And we all know the history of our country going all the way back: no taxation without representation, and all the folks of all colors that have bled and died for the right to vote. Unfortunately, what's happening now is these two values are being drawn into conflict. And these are issues that this legislature is going to need to fix. I think the problem that we have here as it pertains to the issues regarding removal of school board members is that you have an overreaching here, because what you state the obvious, you have constitutional officers that are being removed by appointed individuals. Again, local board members are constitutional officers, and they're being suspended upon the recommendation, not necessarily the recommendation of a private organization, okay? It's just something that's written in the state law, that this is the triggering mechanism, that when the school system is placed on accredited probation, the notification goes to the State Board of Education. You crank up the wheels as to whether or not they're going to be suspended or removed. The problem that you're having here is that you're relying on reports compiled by a private organization. And those reports sometimes, not all the time, but in the two cases I've been involved in, including Sumter County, in which the court has issued an injunction to prevent the State Board of Education from going forward on that matter. What you have is a reference in those reports to unnamed individuals. Now, I'm telling you, as an attorney, this is very difficult. Because let's face it, if you are an administrative law judge under Title 45, if you are a State Board of Education member, and you got to make a decision to protect the education and the ability of students to go to college, or whether or not you're going to protect elected representatives on a local board, it's an obvious decision what's going to be made. You're going to make a decision to protect children and taxpayers. That's obvious. And I appreciate the difficult situation that any administrative law judge or any State Board of Education member, including the governor, is put in when they're faced with that decision. This is a matter that this legislative body needs to fix, it needs to address. However, this is also a problem that, because SACS has so many problems, with credibility. That's the problem that SACS has. It's a problem with credibility, because all the two cases I've been involved in, they never dealt with school performance or student performance. This was simply political infighting, plain and simple. When SACS says they want school board members to work more closely, when the state law says that the majority of the board controls the board, but SACS disagrees with that and finds that as an accreditation problem, SACS has a credibility problem. Because not on one of these cases was there ever was there any testimony that the boards were not working, that they weren't getting things done, that principals were complaining that the school boards were not attentive to their needs? Again, it never went back to the functioning of the schools or the student performance. Instead, what it came down to was a written report prepared by SACS. They're a private body. They handle their situation how they handle it. That's their business. The problem is that the government has decided to take their report and use that as a basis to effectively avoid an election. So when you are an attorney and you have to represent school board members in this matter, and you are questioning the efficacy and the veracity of the report, and there are no individuals named specifically when it says school board members failed to respond to stakeholder concerns, my question always is, well, what stakeholders are you talking to? Are you talking to members or constituents of my clients? Did you go to District 1? Did you talk to the pastors of their church? Did you talk to neighborhood leaders? That information is never revealed. And in fact, as an attorney, I can't even get hold of it. Why can I not get hold of it? It's a private organization. And in fact, during the hearings on some of this, the testimony was that it was a common practice for the investigators and the review team to not retain the notes of the people that they talked to. Now, if we were trying a civil case, that's called spoliation of evidence. And that information would be taken and used most strongly against the person who destroyed the evidence. SACS has a credibility problem.
Amen.
And what they should do is what they are asking these school boards to do, to be a bit more transparent.
Amen.
I appreciate the position, the power, the effectiveness that they've done with colleges and universities. But we got two values here that are competing against one another. One is education, one is the right to vote. And if you're going to get involved in a situation and you know you're going to be called, because as soon as the report is written that a system should be on accredited probation, the call should go out to the review team, to the investigative body. Now hold on, y'all. Now you know we're going to have to go testify before the State Board of Education. Get your ducks in a row, get your evidence together, because you're going to be questioned. Let's have the witnesses available, if necessary, to come testify why this school board, why these members should be removed. That was not done in this case with Ms. Roberts and Dr. Culver. And as far as I know, thus far with the Sumter County case, we still don't know exactly who the stakeholders were that SACS talked to arrive at their decision. We don't know what notes they reviewed, because again, when I go talk to my clients and I talk to their constituents, they don't have a problem with their elected representatives. Instead, the problem is you now have boards that, because of demographic changes, the complexion of the majority has changed. And unfortunately, because the complexion of the majority has changed, somebody has made a complaint. SACS, you got a credibility problem. Because I am aware, Ms. Roberts has evidence of it, Dr. Culver has evidence of it, you have other people who will testify. When people have complained to SACS about problems with the school board, they got no response. No investigation, no review, and the complaints mirrored the same type of complaints that were made against people such as Ms. Roberts, Dr. Culver, and people from Sumter County. SACS, you got a credibility problem. And because they hold so much power, and because state boards are relying upon them, my suggestion to SACS is clean up your credibility issues. Because you are being used to void an election. Two values that this country and the citizens deeply cherish. Now, so when we get to a hearing, you have a problem with trying to refute any type of evidence. And then we get to the point where we have to leave it to the courts, spend thousands of taxpayers' dollars. Mind you now, Ms. Roberts and Dr. Culver didn't use taxpayer dollars to defend them. It came out of their own pockets. although they voted, they were blocked by their own board from doing so and by the superintendent. They came out of their own pockets to defend this case all the way up to the state Supreme Court. So my suggestion as a remedy here is that this legislature has got to fix this issue. I don't know how you're going to do it. Maybe I got to sit down and think about it a little bit more. And maybe I can offer some suggestions. In fact, it appears that one of the suggestions that we argued in our case before Sumter County is already being followed. That is, the school board, the state board should not be given an all or nothing proposition, which is to remove all or none of the school board members, because the problem in that case was that was going to be the issue. And the argument made before the judge, which was so compelling, is each individual member conduct must be shown to have threatened the accreditation of the school system. In other words, their conduct must be causally related to the loss of accreditation. And if it's not related to the loss of accreditation, you don't have any evidence to support the verdict of removal or the recommendation of removal, which is a due process violation. Now, the State Board of Education and the State Attorney General's office seem to have changed their position as it applied to the DeKalb County case, because they didn't recommend suspension of all 3 school board members. My suggestion also is that there needs to be at least the appearance of some type of equity in responding to complaints or requests for investigation that constituents make to SACS. SACS may want to come forward and justify on what basis it decides it's going to go forward with a more formal investigation. There needs to be retention of any type of evidence used to formulate its decision to recommend accredited probation, knowing that a State Board of Education will be relying upon that. Because again, the whole issue, you're going to run into these conflicts of values of education and the right to vote. So if you're going to remove somebody or recommend they be removed, suspended from office, let's see the evidence that's going to support it. And let's not just rely upon a report. And poor Dr. Elgard, let's face it, he just has a report that he's relying upon and he's testifying to the body about. Well, we need to have more evidence before that is done. I think that's only fair to the members of any local board when there's a recommendation that they be suspended. Further, let majority rule, which is a written state law, apply. Don't recommend loss of accreditation just because you don't have a majority vote. That's just a democratic, you don't have a unanimous vote or a super unanimous vote. It's just a democratic process. And unfortunately, if SACS is going to get involved in that, especially at a time when the complexion of the majority of the board has changed, you're just asking for trouble. You're asking for your credibility to be attacked, especially when there is a record of other complaints in the past prior to the complexion of the board changing, and there's been a lack of a response or a perceived lack of SACS to investigate those prior complaints. So in saying all this, there needs to be more transparency. But most importantly, the Georgia legislature needs to remedy and fix this problem here and come up with another fix as to how to address these situations. I just find it pretty compelling that, a number of school boards have problems, but it is only because these boards, the complexion of some of these boards have changed. Save except Miller County. I'm familiar with that case too at Miller County. But I'm also aware that a lot of those facts as pertain to Miller County may be perceived as a lot more egregious. But again, we're talking about issues here of perception and of credibility. And for the benefit of the State Board of Education, of the Governor's Office, as well as for SACS, before you make a move to void an election, you need to have good credibility before doing so first. Thank you.
Can we just go to the point, you probably will get an opportunity to express your concern in the question and answer, if you would. Can we go with a question, and then if it's something that's so burning, after we finish, I'll give you an opportunity to amend your statement.
Thank you, Mr. Chair. Thank you, Ms. Roberts, Dr. Culver, and to you, Attorney Watkins. I have a question. I know the first case, the Warren case, was based on Title 45.
Correct.
Did you go through the administrative law?
We did. We went through the administrative process because that's what the law called for. In fact, what that law called for was complaints to be made, and it could still be made now to any other official whose office is created by general statute. A private citizen can make a complaint to the governor. The governor then refers that over to the administrative law judge to schedule a hearing, and you begin the process right there.
You followed Title 50 under the exhaustion.
That's correct. It was Title 50. Correct.
So then you went before the Superior Court after that?
That is correct.
Okay. And they said as an appellate court?
That's correct.
Did the administrative hearing officer render findings of fact and conclusion of law?
He did.
Then when you went under Title 20 in the Sumter County, did you go before an administrative hearing officer?
For the State Board of Education, we had the initial day of hearing. It was continued to give that board an opportunity to resolve its issues, which was a recommendation by SACS to give them time to work through their problems. The problem we had, you had 3 board members who did not want to continue the process of trying to mediate.
My ultimate question, in both of those cases, regardless of the statute, how, because you didn't have the burden, right? The burden was on the party.
That's correct.
Okay, so how did the individual board members, how was it shown that there was a nexus between the action and the individual board members? What was the evidence?
You had some testimony that was taken. Mind you now, and this just is going to be the difference of opinion here on how the evidence is being construed. One thing the administrative law judge said, and it really made me appreciate his position, he always said the local board signed up for SACS. Since they signed up for SACS, they got to play by their rules. I'm paraphrasing him now.
This is in Warren County.
This is in the Warren County case. And he felt that because this was an issue affecting accreditation, that rose to the level to authorize him to recommend removal. Just because they violated SACS standards. He kind of saying he didn't have much choice. SACS made their report. The report's been entered into evidence. It was...
regardless of hearsay or anything else?
Correct. Now, it's funny because some of the issues involved in that case involved First Amendment issues. That is, what a school board member may have said at a hearing. They were charged with discrimination, but they couldn't prove the case of any type of discriminatory conduct on the law. That is, there was no adverse action. It was just a statement made. So, you know, so even, and that was the same issue that potentially could have, you know, but nonetheless, go ahead.
2 more questions, Mr. Chair, if I may. Under the Warren County, understood you say the Supreme Court reversed it because of the constitutional officer argument.
That's correct.
Now tell me, what did the Supreme Court say that stopped, what was their finding that stopped the Department of Education going forward with their hearing?
Superior Court?
The Superior, okay, you went to Superior Court.
When it pertains to Sumter County.
Okay.
Correct.
Now, what was their theory of stopping it prior to having that hearing? There
was one, that it was all or nothing proposition, and the judge was concerned that there would not have to be any specific findings of fact for a particular member before the recommendation of removal. The second issue was, and this is a big problem in this case, with Title 20, that board members have no right of appeal, that if you are recommended for suspension, you can't appeal it. As written in other statutes, you can't go to the Superior Court. Instead, you have to petition for reinstatement. And this is the most backwards part of it to me. You have to prove at that...
You have to show cause why you should be allowed to come back.
Retain what, and this is the standard though. It's not that the State Board of Education erred in their findings of fact or conclusions of law. That's not the standard. The standard is you have to prove that the school system will likely retain its accreditation or regain its accreditation. And my question to the judge was this: how are you going to prove that? You're going to call somebody from SACS who has 2 to 3 levels of review before they make a recommendation regarding accreditation? Investigative team, I believe it is a review team, and then it goes to their national commission. Who are you going to call to prove that? You can't prove that case. So any person that is suspended from office, as an attorney, I just don't know how you prove that case. If you call Dr. Elgar, I would presume he's going to say that is a recommendation that has to be made by the investigative review or the national team as to whether or not this particular individual will assist that school system in regaining or reattaining its accreditation. That's what I presume he would say.
Are there any other questions?
One quick comment. Thank you all. Sort of like a neighboring county for Augusta, and just want to let everybody know that Augusta is being represented. Brian is from Augusta, and we appreciate you.
That's right.
I will make a comment.
Can we save our comments to the end?
Okay.
Yes, let's do that. Well, while we're here, we have Miss Reverend Wright from Sumter, and I guess while you're there, we can go on and just tie all of both of you all in together. Did you have one other comment that you want to make, Dr. Coleman?
Well, yes. One thing, and I hope this has become a real issue for our county, and that is, I did not like the idea about the parents being upset because of thinking about their children losing their SACS accreditation. And I'm going to make a move to try to prevent this from happening in the future. That is, get accredited by the GAC as well. Just in case they have a problem, you have at least you have a chance to work through it, so they won't be in a critical stage of being upset and that kind of thing.
Thank you. Reverend Wright, can you come up? You're from Sumter, and since you have your attorney here, we'll just do all of that at one time. Reverend Wright, we're honored to have you here. We appreciate you coming up from Americus, Georgia. Reverend Wright he has held many capacities down in Sumter County. Currently, he is the founding chairman.
Yes.
Of the Georgia Association for the Advancement of All People. Thank you, Reverend Wright.
Well, good evening. So far, what I've heard is everyone says that they don't have a problem with SACS. I have a big problem with SACS. In my experience thus far, the 3 most racial bodies of people that I've came in contact with have been the Professional Standards Commission, the Georgia School Board, and SACS. And I'll save the first 2 for another day. Today we're going to talk about SACS. When I first became involved with SACS, it was in 2008. At that particular time, we still had a 9-member board panel, just like we have today. Except for the makeup it was 5 white folks and 4 black folks. And every critical vote, it always went 5-4, 5-4, 5-4, 5-4. So there were some issues that had came up where I had gone to talk to the board and to show you how the politics work, and that they have, say, the inside connection or the good old boy system. That particular board that was made up for 5-4 was even bold enough to give it to me in writing that they would not talk to me at the regular board meeting. So now here I am with a letter from the chairman, then was done in minute, that said they wouldn't even discuss anything with me. So I went down the exact same path that the white folks are going down now in 2011 and 12, complaining to Sachs. These are some of the letters I got back from Sachs that's in a nutshell that says the majority rules. That's what they say in a nutshell. And just to say that the policy about what they're supposed to do, this one was revised in May 9, 2006. And in 2011, this same policy was in effect. Except the only difference was the board had now switched because of geography. It was 6 black folks making the decision. And it is a lie that the vote always went 6-3 because there was one black person on the board who occasionally did vote with the 3 white people. And so some votes were 5-4. But because of